$29,000 for overgrown grass, $16,000 for cracks in the driveway, $100,000 for parking incorrectly on your own property. These are some of the outrageous fines IJ's clients have faced, often for harmless violations. The prohibition on excessive fines is one of our oldest rights, but governments, from small towns to federal agencies like the IRS, still issue ruinous fines, and courts still rubber stamp those fines. I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, joined by co-host Keith Neely and IJ attorneys Sam Gedge and Mike Greenberg. This is Beyond the Brief. Sam, where does our protection against excessive fines come from, and what makes a fine excessive?
It comes from the excessive fines clause, Kim, as the name suggests. The excessive fines clause is housed in the Bill of Rights in the Eighth Amendment. And when most of us think of the Eighth Amendment, we normally think of the cruel and unusual punishments clause that comes up in high-profile death penalty cases at the Supreme Court every year. But there's also an excessive fines clause baked into the Eighth Amendment. And as the name suggests, it secures our right to be free from excessive fines. Now, how do we kind of determine what fine is excessive, which I think might have been the second part of your question. Maybe it wasn't. So that's kind of that's a hard question. And it's one that the courts are only recently beginning to grapple with. So the excessive fines clause really didn't get much attention from the courts until the past 20 years or so. So it's a really kind of exciting area of law in that there's not 200 years worth of precedent. There's not even, frankly, 50 years worth of precedent for us to work with. So it really is at the cutting edge of constitutional litigation.
What's the reason for that? Why is the excessive fines clause kind of a recent trend in the court's decision making?
Honestly, I don't know, Keith. But I can tell you that the first time the Supreme Court even addressed the excessive fines clause was in the late 1980s.
Wow.
There's only been maybe 4, possibly 5 excessive fines cases from the Supreme Court in our nation's history. So it really is kind of still a growth area when it comes to Bill of Rights litigation.
So one of those Supreme Court cases was an IJ case, right? But it didn't deal with this question of, is this fine excessive or not? It dealt with kind of a weirder constitutional thing.
Definitely weird, Kim. Correct. Yeah. So this is the Timbs versus Indiana case, which IJ litigated at the Supreme Court back in 2018, 2019. And you're right. The issue there, at least before the Supreme Court, was not, whether any particular fine is excessive. It was this kind of first order question of whether the excessive fines clause protects against fines imposed just by the federal government, or whether it also secures our right to be free from excessive fines imposed by state governments and municipalities, whether we're talking about like state police, the local dog catcher, just like any kind of government actor. And in Timbs, the U.S. Supreme Court said, yes, of course, the excessive fines clause applies to states and to municipalities, just like the First Amendment, just like the Second Amendment does. And so, it was an important case, and I think really kind of revitalized interest in the excessive fines clause nationwide.
A Marion man who's been fighting for 8 years to get his car back from police is celebrating a big victory this week. Police seized Tyson Timbs' Land Rover back in 2013 when they arrested him on drug charges. They can do that under what's called civil forfeiture. That lets authorities take somebody's property if they think it's connected to a crime. But Timbs and his lawyers argue that taking his $40,000 car was excessive given the crime. And this week, the state Supreme Court agreed with him. It ruled that forfeiting Tyson's car was overly harsh and violated the Eighth Amendment's excessive fines clause. That does mean that Tyson gets to keep his Land Rover.
And that's called incorporationism, right? The process by which the court has slowly held over the years that provisions in the Bill of Rights apply against the states. Are there any provisions of the Bill of Rights that haven't been incorporated yet? I think the quartering, is there anything else?
There are a couple. Yes, the Third Amendment's quartering of soldiers clause, I believe, has not been incorporated. I think the Third Circuit maybe has indicated that it has, but as you probably know, Keith, the Third Amendment's criminally under-litigated in modern American history. But the other ones there, the Seventh Amendment's right to a civil jury trial has yet to be incorporated, and aspects of the Fifth Amendment, I believe. Okay. But most everything in the Bill of Rights now does apply to the states as well as to the feds.
Why does incorporation matter? It seems like, all of the states are subject to the Constitution. Why do you have to go through this whole process of saying, yeah, no, we're serious?
Yeah, well, it matters because, I think your instinct is sound, which is that all states should be subject to the Bill of Rights. But without incorporation, the states, in fact, would not be subject to the Bill of Rights. So when it comes to dealing with state actors as opposed to federal actors, without incorporation, there would be necessarily no federal guarantee against states infringing your right to speech or to bear arms or to any of the rights that we kind of take for granted as being fundamental to our system of ordered liberty.
And that's in part right because the Bill of Rights itself is framed in terms of limitations on Congress and the federal government. So by the text, it's almost as though the Bill of Rights wasn't intended to apply to the states because at the time of the founding, it didn't. But then after Reconstruction, you had the 14th Amendment, and then that's what developed this movement of incorporationism. Is that right?
That's absolutely right. So under the 14th Amendment, post-Civil War, we have all these amendments whose real goal was to ensure that states are being required to honor kind of a baseline degree of federally protected rights. And so we have the Due Process Clause, we have the Equal Protection Clause, the Privileges or Immunities Clause, all of some of IJ's favorite parts of the Constitution.
Right.
And part of those amendments and the doctrine developing around them is the idea that, well, by way of this 14th Amendment, the original Bill of Rights protections are being kind of incorporated against the states as well.
So getting back to Timbs a little bit, that was actually a civil forfeiture case. It wasn't a case about, you're being charged a lot for, not mowing your grass or something like that. And so how does the kind of idea of excessive fines and the idea of civil forfeiture, how do those things interact?
Yeah, so this goes to one of the Supreme Court's few excessive fines cases from the 1990s. It's a case called Austin versus United States. And that was a civil forfeiture case. And in that case, the Supreme Court unanimously agreed that when we're talking about fines within the meaning of the Eighth Amendment, we're not narrowly focusing on kind of pecuniary sanctions, where someone is being forced to pay currency alone to the government. Basically, they say when the government's taking your stuff to punish you, at least in part for something, well, that's going to be a fine, because otherwise there would be obvious workarounds. The government could say, well, we're not going to take your money for committing a crime, but we're going to take your house, and we're not within the ambit of the excessive fines clause. The Supreme Court kind of knocked that idea on its head pretty swiftly. So that's why in Tyson Timbs' case, we're talking about civil forfeiture, as you point out. The government wasn't trying to kind of fine him as we would kind of view it kind of in a colloquial term. They weren't saying pay us $50 or $100. They were saying give us your $42,000 Land Rover as a forfeiture for some very low-level drug crimes. And based on Supreme Court precedent, despite the state of Indiana's best efforts to argue otherwise, based on Supreme Court precedent, the courts agree that, yes, this does fall within the excessive fines clause.
And, well, Mike, one of the weird things about forfeiture is that it's a suit against the property. So how does the excessive fines clause come into play when, in this legal fiction, the government is going after the property, not the property owner? So is there any sort of tension there? Do courts struggle to resolve that in the forfeiture context? How have courts wrestled with that legal fiction when it comes to applying the excessive fines clause in the context of forfeiture?
It's sort of an open and difficult question, right? Because as you point out, the legal fiction of civil forfeiture is that the person didn't necessarily do anything wrong. It's the property is guilty of doing something wrong. Whereas, as Sam pointed out in this Austin case back in the 1990s, we have the U.S. Supreme Court saying that civil forfeiture is, in fact, a fine. It is a punishment against the person in some way, shape, or form. And so that kind of lends to the question of, well, I think at IJ, we largely think that, well, civil forfeiture should be unconstitutional as far as it allows people to be punished without actually being convicted with or charged of a crime or anything like that. That's one of the things that we're litigating in our Detroit forfeiture class action right now, which is that county or state doesn't allow for an innocent owner defense to a forfeiture action at all. And so one of the things that we're arguing is that under the Eighth Amendment, as far as that system kind of allows people to be or have their property taken without actually them having done anything wrong, without, like, as far as they're able to be punished without having done anything wrong, that whole system is unconstitutional under the Eighth Amendment's excessive fines clause.
Yeah, it seems like talking about Tyson Timbs is a slightly different situation because there it's sort of a proportionality issue of, he did this low-level thing. He is being charged, effectively $42,000 for it, which is, and also like his only means of transportation, which is, an even bigger deal. But for somebody who's just entirely innocent, charging them $1 or a nickel seems excessive because they have done nothing wrong. There's nothing to punish them for. Are courts able to kind of understand that, or how does that go in court?
We're working on it. It's one of the claims that we're litigating in our class action lawsuit against Detroit right now. But as Sam pointed out, like the excessive fines clause has been so under litigated that it's something that really hasn't been squared away. Another thing that we litigate a lot of challenges to civil forfeiture systems nationwide. And unfortunately, many of the problems with civil forfeiture, there are a lot of low-hanging fruit problems that go beyond the fact that any given forfeiture might be an excessive fine. So it's not the case that every single civil forfeiture case that IJ brings has an excessive fines defense to it, but we're getting there.
Sam, could you walk us through a little bit of some of the issues that come up in these types of cases? Because the excessive fines clause itself doesn't define what excessive is. It doesn't define what a fine is. As you pointed out, courts really haven't been deciding this question except in the last 20 to 30 years. So, how does a court, as it's trying to apply this provision today, think through the different issues? How does it determine what a fine is, whether something is a fine, what makes a fine excessive? How does that all kind of play out under the court's current case law?
Yeah, so nationwide, the governments are increasingly trying to basically steal a base when it comes to the threshold question of what is and isn't a fine, what falls within the excessive fines clause to begin with, and then the second order question of okay, we're within the compass of the excessive fines clause, what makes this particular fine excessive or not excessive? On both of those questions, we see governments really kind of trying to push the envelope, and courts to greater or lesser degrees either accepting those invitations or pushing back on them. And again, not to toot IJ's horn, but we've been trying to kind of place ourselves at the forefront on all of these issues. On that threshold question of what is or isn't a fine, that's something that we attempted to tee up to the U.S. Supreme Court a couple of years ago in a case involving an octogenarian lady named Monica Toth, lives near Boston, Massachusetts. The federal government there, I was going to say fined, but we'll say penalized her to the tune of about $2.5 million because she failed to file basically a one-page form with the IRS reporting that she had a Swiss bank account, which sounds kind of ominous, but in fact, her family had connections to Switzerland, and her father had given that to her. The federal government in Monica's case successfully argued that, well, no, it's not a fine, it's a penalty. And so it doesn't matter whether it's excessive or not. The First Circuit in Boston kind of accepted that, at which point we at IJ got involved, asked the U.S. Supreme Court to take the case, and they didn't, which is disappointing. But Justice Gorsuch dissented from the denial of certiorari of review in that case and basically said it sure looks like a fine when you're, fining her $2.5 million, which was heartening to know that we weren't crazy for thinking that. And since then, in fact, the 11th Circuit has explicitly picked up on Justice Gorsuch's reasoning, and they've created this open split with the First Circuit on this question. So that's one area where we see governments trying to kind of get themselves out of the excessive fines clause by really kind of trying to gerrymander what is and is not a fine.
Well, let's pause there for a second. So in Monica Toth's case, why wasn't the $2.5 million penalty a fine? Because, I think anyone listening would think to themselves, well, that's self-evidently a fine. So what was the basis for the First Circuit's distinction?
Yeah, so they made a couple of analytic moves, Keith. One is they said, well, it's in civil court, it's a civil penalty. And sure, yeah, the Austin case we were talking about from the 90s, well, that was in civil court too, which suggests that maybe that distinction shouldn't matter. But the First Circuit said, well, maybe it kind of matters, even though Austin basically said it didn't. And the other move they did was basically say, well, we're not going to say that a payment is a fine if what it's actually doing is simply compensating the government for a harm that you've caused. So if, for example, you blow up a post office and the government says we would like you to pay for the new post office, that's not going to be viewed as a fine because you're basically just restoring the status quo. The First Circuit really kind of stretched that concept to the breaking point because, in fact, Monica Toth did not cause $2.5 million of harm. But they said, well, it's roughly close enough.
How close is close enough? Because this is, you didn't declare this thing. That's $0
She
worth of
failed
harm.
to
The IRS is sad.
It was a one-page form that I mean, and is the IRS claiming that they would have been entitled to that money if she'd filed the form?
No, absolutely not. I mean, I share your outrage, just to be clear, guys. No, so during the years where she'd failed to file the form, I think she underpaid her taxes by some amount. It was like maybe $20,000, which is a lot to me, but in the big scheme of things in this case is relatively small. But she paid the back taxes. She paid penalties on those back taxes, and then on top of that, the government then hits her with this multi-million-dollar penalty for the paperwork error. So yeah, I mean, I think kind of couching this as in any way kind of compensatory or remedial really is something of a stretch. And again, that's something Justice Gorsuch points out in his dissent that the 11th Circuit has seized on in recent months and saying, well, no, this obviously is a fine. The government's trying to punish people when they take millions of dollars away from them for breaking the law.
Right.
So going back to Timbs a little bit, can we talk about what happened in state court there? Because we went to the Supreme Court, we won, but it wasn't over, right? We had to do a whole bunch of other things. So can you talk about how that played out?
Sure. And you're exactly right, Kim. So the Supreme Court ruling basically got us in the door to the Eighth Amendment because initially the Indiana Supreme Court, before we got involved, said, kind of like the First Circuit in the Toth case, said, we don't care if this particular forfeiture is excessive because we don't think the Eighth Amendment's excessive fines clause applies to states to begin with. The Supreme Court says, well, no, you're wrong about that. That doesn't necessarily mean that Tyson gets his car back immediately, though. It means the case goes back to the Indiana courts to determine whether the forfeiture is a fine, whether it is excessive. And so I think we ended up litigating Tyson's case after the Supreme Court victory for another 2 or 3 years. We had 2 arguments before the Indiana Supreme Court. Went back for a second trial in Marion, Indiana, kind of in north central Indiana. And ultimately, we ended up persuading the trial court, which had originally ruled for Tyson. We persuaded him again that yes, taking Tyson's $42,000 vehicle, his only means of transportation, as you pointed out, for these relatively low-level crimes is disproportional to the gravity of his offense. The state of Indiana appealed, so now we're back at the Indiana Supreme Court for a third time, and the Indiana Supreme Court, and I think a really kind of path-breaking opinion, said, yeah, that this does violate the excessive fines clause.
This started because I wanted it back. I've kept going because I don't want this to happen to anybody else.
And those 2 opinions from the Indiana Supreme Court post-dating our victory at the U.S. Supreme Court, I think have gone a long way towards mapping out a really property rights protective analytic framework for other courts to use as a model going forward.
So, Mike, switching to sort of more traditional excessive fines cases that are about literal fines instead of about forfeiture kind of things. There's a couple of cases in Florida involving people being charged, outrageous amounts for super minor things. Can you kind of give us a highlight of that?
Yeah, in Florida, as across the country, but Florida might be ground zero for this kind of thing. Local governments love using their property code to raise revenue, basically, and to fine people outrageous sums of money for what we at IJ think are rather small violations of kind of aesthetic harms. The first is a guy named Jim Ficken who lives in suburban Tampa, Florida. He had the horrible offense of letting his grass grow a little too tall. The city capped it.
Oh my goodness.
The city capped the lawn height at 10 inches, and Jim's grass grew a little taller than that. And unfortunately, he had a lot of things going on in his life at this point in time. His mother was dying, and he was making a lot of trips out of state to kind of take care of her. And then when she passed, to settle up her estate. And so when he left town this one time to go and settle up her estate, he hired a guy to mow his lawn. And unbeknownst to Jim, that guy passed away also. And so at some point while Jim is out of town, a code inspector kind of drives by and sees that the lawn has grown too tall because no one is there mowing it, despite Jim's efforts to have someone mow it. And then he gets back, and Jim tries to mow the lawn because Jim sees that it's too tall, and his lawnmower breaks.
I was working on the car one Monday morning, and the inspector comes by and says, "You're going to get a big bill from the city."
The man he paid to mow his yard died unexpectedly. His grass grew higher than 10 inches. The city noticed, fining Ficken $500 a day.
I was shocked, especially since they didn't let me know that it was running $500 a day until after it already run for about 7 weeks.
Sky-high fines added up to nearly 30 grand, according to this newly filed lawsuit against the city of Dunedin.
And that's about 5 or 6 years of living expenses for me. So they're really trying to take 5 years of my life.
Wow. Okay. Well, let's start with the excessiveness question, because that's, as you hear that story, first there's the excessiveness of $500 for a day of tall grass. That in and of itself seems kind of excessive. But then there's this kind of second order question of, well, can a fine that by itself might be constitutionally permissible become unconstitutional if the municipality allows it to continue to grow and grow? So how does that play into the excessiveness analysis?
Yeah, so there are unfortunately two very open questions that you're raising here that the courts have not really come to settle questions on, and unfortunately in Jim's case they came to the wrong answer in both of them. The first is this broader IJ theme of deference to legislatures, to the elected branches, rather than judicial engagement. In Florida, there was a statute that says up to $500 for any code violation, no matter what. Like, that's what the fine can be.
$500 like a day.
$500 per day. No matter whether the code violation is tall grass or, improper parking, as we'll get to later, or something that is really, really serious, like, your roof caving in on a commercial building or something like that. That's what the range of penalties was. And the second question that we have to get to is, do we count the up to $500 every single day fine as the fine that is excessive or not? Or is it this kind of aggregate amount that accumulated over time, the $28,000 or $29,000? Which one are we looking at? And this is part of the problem of the excessive fines clause just being under litigated at this point, is there's just not a ton of precedent on this. And the 11th Circuit in Jim's case came out the wrong way on both of them. They said that we only look to that daily amount, that $500 or up to $500, or in Jim's case it was $500 amount, rather than the actual aggregate amount. We don't look at the underlying facts to figure out kind of how it got to that point. It's just, what is the amount because you violated this law and ordinance every day, period, end of question. And then that second question of, well, is this $500 fine per day excessive? The court kind of took a tack that made the excessive fines clause not really do any work, because what the court said is the statute says that fines can be up to $500. This fine was $500, so it wasn't excessive, period. That, of course, leaves the excessive fines clause doing no work at all, because the fine would already be illegal if it was more than $500. So that raises the classic IJ theme of deference to legislatures of, well, sure, a fine can be excessive even if a legislature thinks that it's not excessive.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? You can help end that abuse with a cryptocurrency gift. Every donation helps ensure IJ's fight for justice continues. Crypto is fast, secure, and tax efficient. Maximize your impact today by visiting ij.org/crypto to make your donation.
Well, and Sam, maybe you could shed a little bit more light here on the history of the excessive fines clause. I know we talked about it, where it's rooted in the U.S. Constitution. Of course, it dates back much further than that, as many rights in the U.S. Constitution do. I understand it goes back to the Magna Carta, which was hardly a document of legislative deference. Can you share a little bit about what the history of the excessive fines clause might say about this?
Sure. So you're right, Keith. This goes back to 1215 at Runnymede, where you have the Magna Carta protecting against what they called amercements, which is a, I guess, pre-medieval term for fine. And a lot of the key principles that we see playing out in cases, excessive fines cases today, harken back to some of those principles from Magna Carta, from the English Bill of Rights in 1689 thereabouts. And some of those principles are, that we have a skepticism of the government's power to take our property, and that we have a skepticism in particular of the government's power to strip us of so much of our property that it effectively either destroys our livelihood or just seriously impairs us. And a lot of the reasons for that skepticism, I think, dovetail with a lot of the work that IJ does, because this is a point that Justice Scalia made in an opinion in the 80s. Unlike every other form of punishment, fines don't cost the government money. They stand to make the government money. So if the government wants to put you in prison for 10 years, that's going to cost the government a lot of money. They're basically housing you for 10 years. And we can table for a moment, the state regimes that try to charge people for their time in jail. But let's just accept the premise that, okay, it costs money to put people in jail, to execute them, to do all these other kind of punitive things. By contrast, when the government's taking your cash or your car or your home, government typically tends to pocket that money, whether it's the general treasury, whether it's the police department or the prosecutor's office that's actually bringing the case against you, whether in some instances it's the individual prosecutor who's bringing the case. So there are these really distorting incentives that create a danger that fines will be used in a way that's out of accord with kind of the traditional legitimate goals of retribution and deterrence. That's something, again, that dates back to Magna Carta. Now, as Mike mentioned, we have this kind of countervailing idea of deference. And courts often kind of use deference as basically an out to avoid kind of doing much heavy lifting when it comes to excessive fines litigation. They're not helped, frankly, that in many cases, non-IJ cases, the litigants themselves kind of use the excessive fines clause as a bit of an afterthought. So sometimes the parties themselves aren't giving the courts the tools they need to make really informed decisions. But it is worth, I think, pausing to note that it is kind of unusual that we see so much talk of deference in cases that deal with a Bill of Rights protection, right? To your point, Keith, we don't normally defer to the government when it comes to Bill of Rights protections that are designed to guard us against the government. But that's just, I think, one of the peculiarities that we see in excessive fines litigation. And it's something, again, that we at IJ are pushing back on. I mean, when you think about it, there aren't that many Bill of Rights protections where you see the government reflexively insisting, well, we have to defer to the legislature on what isn't speech, or how much of a restriction on speech is okay, or what kind of restrictions on guns are okay, or whether we can quarter soldiers in our homes. So it really is, I'm not going to say the excessive fines clause is unique in this regard, but it is certainly unusual that courts are so reflexively saying, well, we couldn't possibly determine whether any particular fine is excessive, when really of all government actors, judges you would think would be the most qualified to determine whether fines are excessive, because day in and day out, they're evaluating specific offenders and fining them, or assessing fines, assessing punishments based on the characteristics of those defendants. It's
also a little bizarre that we, in IJ's economic liberty cases, for example, you have the legislature passes a law saying, you need an occupational license to do this or that thing. And sometimes we run into courts saying, well, we have to defer to that. It's a little more bizarre in cases where the legislature sets a fine amount, but it's not like it's $50 for this thing. It's just up to $500 or up to this
for
amount
anything,
for a wide range of conduct. And so it's not really the legislature in Monica Toth's case or in Jim Ficken's case that is saying, yes, you should be fined $29,000 or $500 a day for this particular thing. It's bureaucrats at City Hall who are given a lot of discretion to kind of make these decisions, and courts in cases like Jim's and in other IJ cases also are deferring to that. And putting aside whether legislatures are worthy of deference for Bill of Rights protections, as Sam pointed out, I don't think bureaucrats at City Hall are entitled to the same level of deference.
You were talking earlier, Sam, about how, fines are kind of uniquely positioned to raise money amongst all of the kind of penalties available to the government. The part that doesn't make sense to me about that is we're talking about fines that are being charged every day. The person isn't being told that they're being charged those fines, and so they don't have an opportunity to give the money that the government is theoretically seeking. And then it's accruing to an amount that a person couldn't conceivably pay. Like, it's not like Jim Ficken. He's, a regular guy. He doesn't have just like a box with $29,000 in it, like stashed under his bed or something, right? And so there's no way the city is ever going to see that money. And so how can you connect the dots there for me a little bit of like, okay, maybe this is designed to raise revenue, but if they're never actually seeing that revenue, what's the point?
Yeah, well, I think I might disagree with the premise a little bit, because I think the government oftentimes does see a lot of the revenue. Now, there certainly are instances where, and we'll talk about, Mike's case in Lantana in a few minutes, I'm sure, where, the amount of money that's imposed on a particular person, like you look at this person's economic resources, and of course, they're never going to be able to pay this in a million years. But, there is at a minimum leverage for the government. So the government might come in and say, yeah, we're going to charge you $1 million for overgrown grass. They know they're never going to be able to collect $1 million from from you. But if they hang this over your head for 5 years, they might be able to kind of get a payment plan or have you agree to pay, okay, I'll pay $20,000 or $10,000 for my overgrown grass. And all this money adds up. And that's setting aside, of course, kind of the dynamic in forfeiture cases where there is an actual piece of property, of course, that the government is taking. So there's not a concern with people not being able to cough up the money. The concern is that you're, crippling them by taking their cars or their homes.
Well, speaking of Lantana, then, I think this is a good time to talk about that case. Mike, can you break down a little bit what's going on in that case and what exactly the excessive fines clause has to say about a person's ability to afford a penalty and how that plays into whether it's excessive or not?
Sure. So we represent Sandy Martinez in Lantana, Florida. She is a single mother, working class. She lives with her 3 children, her sister and her mother. All of them kind of combined together to make the household work. They're doing their best. And because they have several adults at the household, they have several cars at the household. And they committed the egregious offense in Lantana, Florida, of having one of those cars have the wheels parked slightly on the front lawn rather than fully on the driveway. The driveway wasn't, wide enough to accommodate all of their cars.
It started over a year ago. Sandy, her sister, and her 2 adult children each have a car, and there's not a lot of room for 4 cars in the driveway. This video her lawyer made shows you why.
If I park over the sidewalk, then we'll get a ticket. We can't park on the street because obviously it's a roadway. We can park in the swell, but it's very dangerous, so that leaves us no choice but to park in the driveway on my grass.
The town of Lantana cited her for violating its ordinance, which mandates residential parking be on asphalt, concrete, block, or gravel. Grass is not listed.
And for that offense, Lantana charged her $250 a day, and it would continue until Lantana came out and decided that you have fixed this problem.
Hold on, wait. $250 a day for one car with one wheel on her lawn.
That's what they charge her. And we're talking about the same Florida statute that allows $500 fines for every single day that a code violation exists. Now, mind you, in Lantana, the fine for parking impermissibly on public areas, like overstaying your meter or something, that's a fraction of this. I think it's either $25 or $50, and it's a one-time thing. In Lantana, for code violations, and this is true in a lot of places around the country, you can't just fix the problem and have the fine shut off. That's not how it works. And they don't necessarily come out each day and independently evaluate again whether the violation still exists. Instead, you have to fix the problem. And then at the end of your day, you have to call City Hall and demand that a code inspector comes out and checks their box and says, yes, I agree that this problem is fixed. And that's how you shut the daily fines off. So in Sandy Martinez's case, she got the notice in the mail that she had improperly parked her car. She moved the car around the corner to where there was, some parking on the street. And then she's a busy single mother. She calls City Hall. She leaves a voicemail, says, I fixed it. Come on out and check. And then she moves on with her life because she's got 3 kids to deal with at home and a full-time job. And then a year goes by. She hears nothing. There's no notice in the mail. There's no knock at the door, no phone call, no nothing. A year goes by. She's trying to put her house on the market because 2 of her adult children are moving out. She wants to change houses. And she finds out that there's a $100,000 lien on her property. And she says, I have no idea what this is all about. What is this for? And it's the city of Lantana has a lien on her property. And she calls City Hall and says, oh, yeah, that was for that parking violation from back in the day. That's what it says it's for. And Sandy says, well, I called and no one came out and inspected. Turns out no one ever did. And so for a year plus, $250 fines been accruing on her property for something that the city doesn't even have any evidence has ever actually been happening. Thankfully, the city sent someone out that day, but by that time, the damage had been done. She's got $100,000 liens on her property. And here's where Sam's earlier discussion of how the city plans to collect these things comes out. Sandy, like Jim, doesn't have 6 figures just lying around in cash, but the city's able to attach this fine as a lien on her property. Florida has homestead protection, so they can't foreclose on her property right now, but when she dies, they can foreclose on the property or when she tries to sell it. Also, Sandy went to the city and said, look, I don't have this kind of money. I don't want this attached to my property anymore. Let's reduce this. She explained the situation. And the city said, well, yeah, maybe, but we'll just shake you upside down for everything that you do have, every asset you can possibly squeeze out equity from, and just pay us all of that for this offense, and that will, settle us up here. So that's kind of how these cities plan to collect these things, is through other leverage points that they have. We filed suit on Sandy's behalf rather than her trying to pull out every inch of equity she has from every asset she has. And that case is working its way through the Florida state courts now under the Florida Constitution, where we're trying to get it established as a matter of Florida constitutional law that a fine is necessarily excessive when it requires the offender to pay everything they possibly have for something as trivial as parking improperly on your own front lawn.
Is there a fine like this that wouldn't be excessive? Like, is there a universe where there's some sort of daily accruing thing, it accrues to some sort of astronomical amount, but somehow it isn't a constitutional problem? Would it have to just be like a super loaded guy? Would they have had to have committed some sort of incredibly egregious crime? Like, is there a universe where anything like this could be constitutional?
Mike is getting way more thought about this than I have.
Yeah.
I think the answer to that is it's what Sam and the Timbs team got established in Indiana, is what courts should be looking at nationwide, is really dig into the facts and circumstances of every particular case. It's not just look at the offense as a general matter and say, well, this is kind of harmful, this is kind of not. It's not look at just, well, this went on for a long time or didn't go on for a long time. Look at actually what happened. In Sandy's case, the city has in its records saying this went on for a long time, but if you actually drill down to the evidence, there's no evidence actually that that she committed the offense 365 times, as the city is alleging. Or you can look at to what the person is actually doing. Sandy had prior interactions with code enforcement where they fined her, I think it was $75 per day for cracks in her driveway. So the city, it's not the greatest actor in the world. And so they fined her $75 every single day. And this went on for several dozen days until she could save up the money to fix the problem to what the city wanted her driveway to look like. And so I think courts can drill down into the facts and circumstances and say, what is going on? Is this person thumbing their nose at the city or at the government and just saying, I don't want to deal with this, I don't want to follow the law? Or are they like Sandy, where they're saying, I'm trying my best here and the city is giving me a hard time and they're still fining me, which means I don't even have the money, or I can't save the money to fix the problem and pay the city at the same time.
Well, and the Lantana case makes me think that there are, of course, other ways that a fine can be unconstitutional outside of the excessive fines clause. Thinking here of, you need to have notice that you're being subject to the fine. Lantana doesn't seem to have a lot of that. Or worse, it has this weird burden shifting where the person who is paying the fine now has the burden of showing to the government that they've stopped doing the allegedly offensive conduct. Sam, can you walk us through some of the other areas where either IJ has litigated or maybe we're considering litigating the constitutionality of these sorts of fine processes?
Yeah, sure. So you're right. There's all sorts of ways the government can violate our constitutional rights. We can kind of look beyond just the Eighth Amendment. But just to highlight a couple of them that I think we've touched on a little bit earlier, one is the profit incentive, right? Just as that informs, I think, some of the skepticism of governmental power that gave rise to the excessive fines clause. It also finds a home in due process protections as well, or at least that's what we would argue, and we would say the Supreme Court has ratified that view. So this basically goes to what we call policing for profit. This is a really hot button topic in the context of civil forfeiture in particular, though it's certainly not limited to civil forfeiture. This is the idea that the very police departments and prosecutors' offices that are deciding whether to bring down this really formidable governmental power on us, those same departments and agencies stand to profit institutionally or sometimes even personally from enforcing the law. So, for example, in Tyson Timbs' case, the actual prosecutors who decided to bring that case in Indiana State Trial Court stood personally to get something like 30% of whatever they managed to forfeit from him. Now, Indiana is a little bit unusual in that regard. Unlike almost every other state in the nation, there are certain counties in Indiana that actually do give basically private prosecutors a direct financial stake in the forfeiture cases. But far more common are these kinds of institutional profit incentives where you have, small-time police departments. They know like a big part of their budget's going to be made up of fines and forfeitures. That's, for example, what we see in our Brookside, Alabama case, which really made headlines a few years ago when it came to light that something like 50% of this very small town's budget was made up of fines and forfeitures, many of which were being imposed on poor people or on people who were driving through town from one place that wasn't Brookside to another place that isn't Brookside. So that's certainly one issue that we see recurring, where there's just these incentives to over-enforce in a way that really distorts the public interest that we want police and prosecutors to be serving. I honestly don't remember the other ones on your list, Keith, but maybe Mike does.
Well,
I can jump in with
please, the notice issue or something else.
I was going to say, watchers of the show will recall just a few weeks ago, our colleagues discussed the gobsmacking system in Pasco County, Florida, where they were using code enforcement, fines, and enforcement writ large as a way to just get people to move out of the county who they didn't like, right? So there are a lot of ways in which governments will violate, whether it's the Eighth Amendment or due process principles, using fines as their leverage point to kind of go after people in ways that either benefit the government or harm people that government actors don't like.
Or retaliation. I mean, are there instances of government officials using fines as a retaliatory measure?
Well, yes, absolutely. And even in the Timbs case at the U.S. Supreme Court, Justice Ginsburg, who was writing for the court, made the point that historically, fines are not used just to raise revenue, but also to disable people who the government doesn't like. Because obviously having the government take everything you own can absolutely be a really potent retaliatory measure. And we, of course, are litigating a bunch of retaliation cases in Ohio, Cleveland. Where certainly you see the government bringing down, its full power on folks who the government thinks are saying things that the folks in power don't like.
Yeah, so we should wrap up soon, but do you guys have any closing thoughts?
Certainly can. I think the common thread in our excessive fines work is one that we see for a lot of IJ's work, which is that the government is exercising immense and formidable power, and oftentimes they're doing so in a way that violates people's most basic rights. And I think what in some ways sets the excessive fines clause apart from other areas of constitutional litigation is that the excessive fines clause is right there in the Bill of Rights in black and white. Like, it doesn't require any, what some commentators call like penumbras to determine whether, in fact, excessive fines are unconstitutional. Like, the framers could hardly have been clearer. And yet, even so, you see this Bill of Rights protection being very, under-litigated, under-enforced for much of our nation's history. And even now when courts are taking the time to pay more attention to it, you see courts kind of reflexively retreating to deference when, if there's anywhere where the courts shouldn't be deferring, it's in vindicating rights that the framers decided to put explicitly in the Constitution. So that's certainly, one of the areas of focus for us as we keep on litigating these cases going forward.
And being vigilant about our constitutional rights is why IJ exists. So we'll be here doing it.
Well, thanks so much, guys, for coming in and talking to us.
Thank you.
Thank you.
Thanks again for watching. Make sure to like, subscribe, and tune in for more videos.